Your landlord has a key to your apartment, but do you actually know when they're using it? One New York tenant suspected something was wrong. Items moved, a strange feeling that someone had been there. So she set up a hidden camera, and what she captured on video ended up being worth $500,000 in court. Welcome to Court Decoded. Today, we cover the remarkable case of a tenant who refused to be a victim and turned her landlord's harassment into one of the largest privacy invasion verdicts in recent memory. It started with small things. A coffee mug moved from where she left it. A closet door that was definitely closed, now standing open. The faint smell of unfamiliar cologne lingering in her New York apartment. For weeks, the tenant dismissed these observations as imagination, the paranoid thoughts of someone living alone in a city of 8 million strangers. But the signs kept accumulating. Mail that appeared to have been opened and resealed. A laptop positioned at a slightly different angle on her desk. The unsettling feeling that her private sanctuary had been violated while she was at work. New York tenant protection laws are clear. Landlords must provide at least 24 hours written notice before entering a rental unit, except in genuine emergencies. But proving a violation is another matter entirely. Without evidence, it becomes a tenant's word against a landlord's denial. This tenant decided she needed proof. The tenant purchased a small, inconspicuous security camera designed to blend into home decor. She positioned it carefully in her living room, angled to capture the front door and main living space. Motion-activated recording would ensure nothing was missed while preserving storage space. She told no one about the camera. Not friends, not family, and certainly not her landlord. In New York, recording video in your own home is perfectly legal, even without the knowledge or consent of those being recorded. Audio recording has different rules, but video surveillance of your own private space? Completely within a tenant's rights. The camera began its silent watch. Every morning before leaving for work, she checked that it was functioning. Every evening when she returned, she downloaded the footage to a secure backup drive. For the first 2 weeks, the camera captured nothing but empty rooms and occasional sunlight moving across the floor. Then, on day 15, everything changed. The footage showed the apartment door opening at 11:47 in the morning. A figure entered, unmistakably the building's landlord, keys in hand. There was no knock, no announcement, no emergency requiring immediate attention. The landlord simply walked in as if he owned the place, which, technically, he did own the building. But ownership does not grant unlimited access to a tenant's home. The video showed him moving through the apartment methodically, opening drawers, looking through closets, examining personal belongings on shelves, checking the refrigerator. The intrusion lasted 8 minutes before he left, carefully closing the door behind him. The tenant's hands trembled as she watched the playback. Her suspicions had been correct, but rather than immediately confronting the landlord or calling the police, she made a calculated decision. She would continue recording. She would build an overwhelming case. One incident could be explained away. A pattern of behavior would be undeniable. Over the next 6 months, the hidden camera recorded 47 separate unauthorized entries. 47 times the landlord used his master key to enter while the tenant was away. The entries followed no predictable schedule, sometimes multiple times per week, sometimes with gaps of 10 days. But they were consistent in their invasive nature. The footage showed him reading mail left on the counter, opening medicine cabinet doors, going through desk drawers containing financial documents. On 3 occasions, he entered the bedroom and opened dresser drawers containing intimate personal items. Each entry was cataloged with date, time, and duration. The tenant created a detailed log cross-referenced with the video files. She noted what the landlord touched, examined, or moved during each visit. The evidence was meticulous, methodical, and devastating. Most importantly, she had 6 months of proof that this was not a one-time mistake or misunderstanding. This was a deliberate, repeated pattern of invasive behavior. Armed with irrefutable evidence, the tenant faced a choice: She could confront the landlord directly and risk retaliation, illegal rent increases, fabricated lease violations, or harassment designed to force her out. She could report him to housing authorities and pursue administrative remedies, or she could take the matter to civil court and seek substantial damages. She chose the courthouse. The tenant retained an attorney experienced in tenant rights litigation. Together, they crafted a complaint alleging multiple legal violations. First, repeated violations of New York real property law requiring advance notice before landlord entry. Second, invasion of privacy under common law principles protecting the sanctity of one's home. Third, and most significantly, intentional infliction of emotional distress, a legal claim requiring proof of extreme and outrageous conduct causing severe emotional harm. The video evidence made each claim not just arguable, but provable. 47 documented entries transformed what might have been a credibility contest into an open and shut case of systematic harassment. When served with the lawsuit, the landlord initially denied everything. His attorneys argued the entries were for legitimate maintenance purposes, permitted emergency inspections, or simply did not occur as alleged. Then the tenant's attorney produced the video evidence. 47 separate recordings with timestamps, each showing the landlord entering without announcement, conducting no maintenance whatsoever, and systematically searching through personal belongings. The landlord's defense collapsed. His attorneys attempted to argue the recordings were obtained illegally. They were not, as tenants have absolute right to record inside their own homes. They claimed the tenant had given verbal permission for entry, but could produce no evidence of such permission. They argued the intrusions were minimal and caused no real harm. But the footage of him rifling through dresser drawers and reading personal mail undermined any claim of innocent behavior. The case proceeded toward trial with the landlord's credibility in ruins and the tenant's evidence overwhelming. The court had to determine what 47 invasions of privacy were actually worth in dollars. This is where tenant harassment cases often falter, proving substantial monetary damages for violations that caused psychological rather than physical harm. The tenant's attorney presented expert testimony from a psychologist documenting anxiety, sleep disturbances, hypervigilance, and lasting trauma from knowing her home had been repeatedly violated. The tenant testified about the constant stress, the inability to feel safe in her own apartment, and the profound sense of violation that persisted long after the recordings stopped. For intentional infliction of emotional distress, courts consider the outrageousness of the conduct and the severity of the resulting harm. 47 deliberate intrusions over 6 months, including examination of intimate personal items, met every legal threshold for extreme and outrageous behavior. The pattern demonstrated not mere negligence, but calculated, predatory conduct. The court found the landlord liable on all counts. The court awarded $500,000 in total damages. The judgment included compensation for invasion of privacy, statutory penalties for repeated violations of tenant notice requirements, and substantial damages for intentional infliction of emotional distress. The size of the award reflected both the egregious nature of the conduct and the court's intent to send a message. Landlords who treat tenant privacy as optional, who use their property ownership as license to invade the homes of those who rent from them, will face severe consequences. The landlord was also ordered to pay the tenant's attorney fees, adding tens of thousands more to the judgment. The verdict made local news and sent ripples through the landlord-tenant legal community. Here was proof that documented evidence of harassment could translate into meaningful accountability. One tenant, with a hidden camera and the courage to pursue justice, had achieved what years of complaints to housing authorities often fail to accomplish. This case stands as a powerful example of tenant empowerment through evidence. The landlord had operated for years believing his master key granted him unlimited access to tenants' lives. He likely never imagined that one of those tenants would document his behavior and hold him accountable. The case reinforces several crucial principles. Tenants have robust privacy rights that landlords cannot simply ignore because they own the building. Notice requirements exist for reasons. to preserve the dignity and security of those who call a rental property home. And when landlords cross these lines repeatedly and deliberately, courts are willing to impose substantial damages. Perhaps most importantly, the case demonstrates the transformative power of documentation. Without the hidden camera footage, this would have been one tenant's word against one landlord's denial. With the footage, it became an undeniable record of predatory behavior that no defense attorney could explain away. In the end, 47 unauthorized entries resulted in a $500,000 judgment. A landlord who believed he could invade his tenant's privacy without consequence learned that the courts take these violations seriously. The tenant, who endured months of knowing her home was being violated while she built her case, received both financial compensation and the validation that she had been right to trust her instincts. This case offers a clear lesson for every renter. Your home is your sanctuary, regardless of who holds the deed. Landlords must provide proper notice before entry, and when they violate that requirement repeatedly and deliberately, the legal system provides meaningful remedies. Documentation is everything. Evidence transforms suspicion into proof and proof into justice. If you found this case fascinating, hit subscribe and the notification bell so you never miss a court-decoded breakdown. Drop a comment below sharing your own landlord experiences and we will see you in the next case.